Dear friends, today we are going to discuss a very good case law on who is station house officer or who is officer in charge as per CRPC, and also whether the central police, that is Central Crime Bureau officers, can be treated as the officers in charge of a police station, and can they file the charge sheet and can it be accepted? These are the points in discussion for today. Normally, we may not come across such situations, but already in 1996 itself, there was a judgment that the officers of the task force, they are not called as, they cannot be termed as officers in charge of a police station. Right, now another such incident has come up. Now let us discuss the same. While disposing the criminal revision petition number 34/2018, the Honorable Single Judge Shri B.A. Patil of Karnataka High Court on 18/1/2021, in the case of Dr. M.Gopal, Dr. M.G. Gopal, that is Principal and Dean of KIMS. KIMS means Kempegowda Institute of Medical Science and Research, versus state represented by Central Police, right, held that the Central Crime Branch or CCB is not an officer in charge of a police station, and hence they cannot file the charge sheet. The charge sheet filed by them in crime number, I think 161/2014, crime number 161/2014, under different sections 406, 477, 120B, 114 abatement, read with 34 IPC of Kempegowda Police Station. Right, all these things are there. Anyway, now the very crucial point is whether the CCB officers can be called as officer in charge of police station. So a little discussion about the facts of the case. You may be knowing KIMS, Kempegowda Institute of Medical Sciences, is a very popular institution, and it is run by a particular community people called as a Vakaliga Sangha. They are maintaining the same. It's a medical college there, so normally so much of influences will be there. So it is alleged that the complainant was asked to pay 65 lakhs for the first year admission in 2014, and of course he will be admitted through some the so-called management quota. But even though he paid the 65 lakhs plus some other amount for development, for education fee, all these things, but still his son did not get a seat, because A1, that is the director of the KIMS, he directed the principal A3 to allot some 6 seats through the circumventing way. But the principal told him that it is not possible, but even then they forced him to accept. Therefore the principal has no other go except to allot them seats. Right, on 3/6/2014 this man was allotted a seat, but when they reported the matter to the All India Institute, that MCA, Medical Council of India, but they did not allot particular seat to this boy. Therefore the seat was rejected. Then he approached and filed a writ petition that the people have collected the money but they were not allotted any seat, and basing on the WP, of course he was allotted a seat, right? But prior to that he has filed a case against the management of the KIMS, that is registered as crime number 161/2014 under different sections of law, that is 420 cheating, 114 abatement, 477 destroying or falsifying the record. All these things are there. So the police, actually the investigation was handed over to the CCB, that is Central Crime Branch, and they have investigated, and ultimately they arrested A1, A2 and A5. They did not arrest A3, he was absconding, I believe. But anyway, they filed the charge sheet under section 173, CRP 173, clause 2. Now the magistrate has taken it on file, but here the objection laid. Now the management, these people, the accused persons in that case, they moved the High Court for revision. Now the point is that, so you may be knowing what is police station, right? You may be knowing according to. So more than that, the point is regarding officer in charge. Let us discuss. So who is officer in charge? Officer in charge of police station means when the regular officer in charge is not able to attend duties, whether he is on leave or other things, then the officer next to him will be the officer in charge. That is what section 2 of the CRPC says. That means the station house officer can be anybody above the rank of head constable. You all know that, right? Then police station. Police station means section 2, yes, it defines any place, any designated place which can be called as a police station, right? Now the point is 173 clause 2. So whenever the investigation has been completed, the cognizance will be taken by the magistrate basing on the report of the officer in charge of the police station. 173 clause 2. Now, whether these people are officer in charge or not, because it is a separate entity, Central Crime Branch, they do not have any police station. They are not officer in charge of police station. They are only crime branch. They will investigate or they will take up cases only on the directions of the concerned department. So even the rank is also not above the station in charge. In Karnataka, the station house officer is inspector cadre. They are not above the inspector cadre. Now, what to do? This is the main point. Right? Now, as far as that 190 taking cognizance, their focus is that the magistrate has not taken into consideration about the fact that they are not officer in charge of police station. He has not examined any witnesses, all these things they have told. But now coming to the point, the High Court has categorically stated that previously it was also decided. So now let us hear the arguments on the other side. So the government pleader, he says that according to section 36 of the CRPC, any superior police officer can act as junior. That means the DGP of a state can act like a constable, no problem. But here the rank is CCB inspector is not above the rank of the SHO or officer in charge. So equal rank, no, finish. Second point, please remember according to 156 clause 2 CRPC also, 156 says about the investigation procedure. Suppose the investigation cannot be called into question even the rank. I will tell you that section will be better for you. 156 clause 2. No proceeding of a police officer shall at any stage be called in question on the ground that the case was one which such officer was not empowered to investigate. You cannot put that question. So government pleader says, so when once they investigated, you can't put a question that they have not investigated all these things. But the court said only one thing, whether they are competent to file the charge sheet, whether the charge sheet can be taken basing on their report. Now, in the case, they have decided on the previous case also, Rakesh Sethi versus State of Karnataka. So in this case also, it was very clearly stated that CCB police, they are not above the rank of the local police, SHO. So since they are equal, only it is the officer in charge of police station who has to file the charge sheet. But here, so since the investigation was handed over to them, they have filed the charge sheet, and now the court has found fault with the lower court also. High Court has found fault with the lower court and ultimately dismissed the revision, holding that only the SHO or the officer in charge has to file the charge sheet. Normally we don't believe. We all know that investigation can be taken up by anybody can be investigated. But filing of charge sheet must be by the officer in charge only. This point, please remember, it will be useful for us for the defense also, and it will be useful for the police officers not to tread on a mistaken path. Thank you.